How did corporations become people? Let's revisit that. Check it out. Leave your comments, ding the bell, share it with your friends, and subscribe to our channel. Your phone calls, and Neil in Gloucester, Mass. Hey, Neil, what's on your mind today?
Yes, our old Governor Romney here believes that a person is the same, or a corporation should have the same rights as a person. But in researching it, I can't find any place where corporations became legal, where there's an amendment to the Constitution or a law that it was created to make corporations legal.
I'll give you a thumbnail sketch of this, Neil. It'll take probably about 3 minutes, but I think it's worth going through periodically, and it's been probably a year since I have. I wrote a book about this. It's called Unequal Protection: How Corporations Became People. And so, if you want any of the references, if you want reference to anything I'm citing here, it's in that book. Number one, in Dartmouth College versus somebody, an 1815 Supreme Court case. The Supreme Court ruled, and Neil, thanks for the call. I'm getting some noise back from you, so I'll just do this without you. But in 1815, the Supreme Court ruled that a corporation was an artificial person. In other words, they had, keep in mind, the corporate form at that point was very, very new. The corporation, as we understand it today, had only existed for about 100 years at that point. And it really bore no resemblance to today's corporations. But anyhow, the Supreme Court in that case, in the Dartmouth case, said corporations are persons, but they are artificial persons. So there's two, and the reason they had to establish some kind of personhood was so that they could sue and be sued, and so they could pay taxes, and so they could be penalized if they broke the law. So we started with that. Then in 1886, the railroad barons wanted to be able to use the 14th Amendment, which says that everybody's entitled to equal protection under the law. They wanted to use this to fight taxes in California. And 6 or 7 of these cases, they were referred to as the California tax cases, were sent up to the Supreme Court by Stephen J. Field, who was the head of the Ninth Circuit at that time, and also on the Supreme Court. Back in those days, the Supreme Court met 3 months a year, and the other 9 months of the year, the guys did what was called riding the circuit. They were out in the field, as it were. And Fields was being bribed by Jay Gould and some of the big railroad barons. In fact, they were telling him that they would help him become president one day if he would just get them corporate personhood. And what they wanted, this case that was brought forward, this was one of the 7 cases. It was called Santa Clara County versus Southern Pacific Railroad. And Southern Pacific Railroad was claiming that because they paid a penny a mile for property taxes in Santa Clara County, but 2 cents a mile it was 2 cents a mile in Santa Clara County, a penny a mile in Santa Ana County, that they were not being treated under the law equally. And the court ruled that that was a spurious argument, that didn't make any sense. That California law covered this. It wasn't even a constitutional ruling. The court ruled against the railroads. And you would think that was the end of it. But the clerk of the court, a man by the name of John Chandler Bancroft Davis, whose father had been the governor of Massachusetts. He's a very wealthy, bon vivant, internationally famous guy. He was the clerk of the Supreme Court. He was there 12 months out of the year. The clerk actually had more power than the Supreme Court justices, arguably, back then. He wrote what's called a head note, which is a commentary on the case. It has no legal standing whatsoever. And again, in this case, the 1886 case, Santa Clara County versus Southern Pacific Railroad, the Supreme Court did not rule that corporations are people. In other words, entitled to rights under the 14th Amendment, the same as natural persons. It did not rule that. But in the head note, Davis said that the Chief Justice, Morrison Remick Waite, had actually said that in an aside to the lawyers when they were arguing the case. And so, as of the time that I wrote Unequal Protection, which was in 2002, there had been 34 Supreme Court cases, and there have probably been more since then. Certainly Citizens United did, where the Supreme Court pointed back to the head note, which had no legal standing, and said, Morrison Remick Waite, the Chief Justice of the U.S. Supreme Court in 1886, said corporations are persons, and we agree. But the court has never officially decided that. But because the court has I mean, the court can quote Mickey Mouse, right? They were quoting a head note which had no legal standing. But the first time they quoted that head note, which was about, as I recall, 10 or 11 years after 1886, it would have been the 1890s, the first time they quoted that head note, that was when it became precedent. So, and then they super established this with the Citizens United decision in 2010, October 2010, as I recall, for Citizens United. So that's how we got here. You've got, this was a doctrine invented by the Supreme Court. It can be fixed by Congress, but Congress has not seen fit to fix it. Or it could be fixed by the Supreme Court, which is why MoveToAmend.org for years has been trying to get an amendment passed by Congress and by the states to say that corporations aren't persons and that money is not speech. So that's the history of it, and I hope that's helpful to you.